Good afternoon, everyone. Thank you so much for joining us today. My name is Jenny Dodson, and I'm the Executive Director for the Healthcare Reform Center and Policy Institute and the Executive Program Manager for the Employer Healthcare and Benefits Congress. We are gearing up for an excellent event, which is happening September 27th through the 30th in Orlando, Florida, and I have many of you attending, so I'm so excited to have everybody joining us today. I can see we have just about 1,000 people joining us, and I can see all of you are joining now. So I'm going to give just a brief overview again of who we are for those of you that don't know. I am, again, Jenny with the Healthcare Reform Center and Policy Institute. We're a nonprofit public policy organization. We conduct independent research and provide innovative and practical solutions for more affordable healthcare insurance solutions. We're run by the national healthcare reform leaders and experts in both public and private sectors. And we provide research and create insight and education through the publication of white papers, webinars such as this, and workbooks, toolkits, and certification programs. I have the privilege today to be joined by Sibyl Bogardus, who is the Chief Compliance Officer for Hub International Insurance Services. Sibyl provides compliance and consulting services regarding health plans and other employee benefits. She has an area of expertise in many things, which include federal and state healthcare reform, ERISA, cafeteria plans, HIPAA, FMLA, ADA, compliance with international revenue codes, and Sibyl is a frequent keynote speaker around the world. She's done hundreds of presentations on the ACA and on other topics surrounding employee benefit plans. She is a faculty of the Healthcare Reform Center and Policy Institute as well, and we're just very privileged to be joined by Hub International. Today's webcast is brought to you by Hub, and it is entitled ACA is Here to Stay, Getting Started on the Employer Mandate Now. Quick housekeeping notes before I hand it over to Sibyl. If you'll look in the right-hand corner, you'll see the Q&A module here as part of our WebEx Event Center. In that module there, you may click in the Q&A area and you can indicate your questions there, and Sibyl will try her best to get to all of them. We'll moderate the questions at the end of this session, so if you think of something at the end, you can also populate your question there at the Q&A module. And so I am going to hand this over to Sibyl. Thank you so much for joining us, Sibyl, and for Hub, we are very appreciative of Hub's information and look forward to disseminating it to almost 1,000 people. So I'll hand this over to Sibyl now.
Thank you so much, Jenny. That's fantastic. Again, the title is ACA is Here to Stay. I've been doing compliance along these lines with employee benefits, with health plans since 1992. And I will tell you, the last 5.5 years have been really a time of delivering news that's not always happy news, but I will preface all of my comments today by saying it's better to know. And it is full speed ahead time. There are new issues and emerging issues, some we've known about and some that are still developing for any employer, even an employer that is over 50 employees, over 100 employees, and really feels like they've got their arms around compliance. There are always new things developing with this law. We also will address concerns around employers that really still need to come into compliance. Just recently, I've had to address a number of issues for employers that have really not done anything. It's certainly the time to come into compliance, and for the smaller employers between 50 and 99 full-time employees, the compliance deadline is going to be in 2016. So there are still employers coming into compliance. There's a lot to do. I'm going to focus a lot of the conversation and discussion today around best practices for compliance and also strategic issues. Lots of things to do. I'm really going to focus on approaching the law systematically, and in fact we approach it with a system that we've developed, and it's really nice to have everything buttoned up to make yourself bulletproof and to make sure that you're not going to pay penalties unless it's something you intentionally would like to do, which in my mind almost no one likes to do that. So we approach the law as avoidance of all penalties, full compliance, and making yourself bulletproof for any investigations and audits. Now, with that being said, let's just jump right in. I've had the privilege of working with a number of employers from small to very, very, very large companies, and it's really important to approach the law, look at it from a strategic standpoint, looking at it as well from a standpoint of administrative issues and dealing with administrative concerns, and also looking at best practices for the compliance and making sure that you've got your arms around everything. We'd like to look at a lot of possible approaches, and we always like to advise on risk. If you approach the law this way, how will it affect you? If you approach the law a different way, what will be the impact? Because there are choices that are made and can be made under this law. Really starting out, we'll look at the top strategic concerns. As I mentioned a few moments ago, some employers have had the ostrich syndrome. Some employers have, simply thought the law would be delayed again, that there would be changes to it. Quite frankly, there would need to be changes by Congress, and we really don't see many changes coming with this. We'll address, that possibility a little bit later, but we just don't see a lot changing with it. So any employer that's really kind of said, I think this is going to go away, it's not going away. Is it too late to come into compliance? I would say certainly not. Even if you had to comply this year and you've not yet done anything and you realize that you're exposed on penalties, it's possible to bring a plan in and to avoid penalties for part of the year because they're prorated, so it's not too late, never too late to come into compliance. One of the things that we stress when we're looking at health reform as a strategic issue is making a 3 to 5 year strategic plan. And one of the main reasons for that, quite frankly, is the Cadillac tax. And you'll see that as a common thread through the discussion today. It's probably the #1 upcoming strategic issue. There are other concerns that employers have around affordability and other issues, but really the Cadillac tax is going to be a key driver for things like implementing a buy-down and other issues. Creating that 3 to 5 year strategic plan lets you look at not just the Cadillac tax, but other issues like wellness implementation, employee communications around changes to the benefit plan, as well as Cadillac tax strategies as plans migrate down more to a bronze level. Certainly you want to start with a projection of your Cadillac tax and then make sure that you're backing into all of the changes and the events and differences that need to occur in your benefit program prior to the date that that's triggered. And of course you'd need to do it before your 2017 plan year. You'd not want to jump off a cliff, so to speak, right before the Cadillac tax attaches to your plan if it does indeed get triggered immediately. And I know for a lot of our clients in the Northeast, especially in the New Jersey area, that is a very valid possibility. A lot of plans are already at Cadillac tax level in that part of the country. The plan designs also are focusing, as I mentioned, on wellness, looking at cost reductions, trying to pull down the costs of the plans overall. Very important, not just for fully insured plans, where you're going to try to get the best rate possible and hold down the costs as long as possible, prevent that horrible compounding effect as long as possible to avoid the Cadillac tax, but also cost reductions within the self-funded context. It's actually, there's quite a bit of play, quite a bit of strategic planning that can be done around reducing costs in a self-funded plan. A little more leeway and a little more play with that than in a fully insured plan, which is a lot more rigid and filed with the state. Certainly the Cadillac tax I've already mentioned, that's a common thread. Looking at funding, and a lot of clients are looking at not just the plan design, but funding and evaluating whether they should stay fully insured and at what point in time do they want to consider shifting to self-funding if they are currently fully insured. Certainly we always caution, this is a risk conversation. It's a conversation about financial ability to self-fund, and not exactly a correlation to size, but certainly the smaller your group, the more variation there is. There are a lot of new products out that almost feel like a fully insured program, but that have the characteristics of self-funding. So we're seeing some small groups, even down to 25 lives, taking on an approach that is a lot more like self-funding. But again, it comes down to the risk. The smaller your group, the more deviation in claims and the more exposure. And a lot more work to do, a lot more analysis of a plan to make sure that your costs are staying in line, and a little bit more exposure, believe it or not, on the Cadillac tax, because if your plan claims are out of line, let's say 1 year out of 5 years, or 1 year out of 7 years, or 1 out of 3, that could trigger a Cadillac tax because of the of increased claims. So you'd want to make sure if you do go self-funded that you're aware of that possibility. Dealing with the details will continue to be crucial. Certainly dealing with the details and looking at whether you can really consistently and strategically approach an issue. Like, for example, if you have a grandfathered plan, should you continue it? There are a lot of analysis points that come into play with that. So that's just one example. And with this law, that I always say it, the devil's in the details. Technology and getting the right technology solution is really a strategic issue at this point. And quite honestly, some of the new solutions, they are amazing, and they can take so much work off of your desk, not just with respect to some of the issues that we focus on usually, like hours tracking and reporting to the IRS, but they can take a lot of extra work off of your plates as well. And when we get to the technology discussion, I'll share a little bit with you about my wish list for some of those programs. Private exchanges are becoming more and more popular, and we will move to a future where we have much more of a defined contribution approach. You still have to offer enough of a benefit credit amount, so to speak, so that the medical coverage itself would be affordable, but a lot of employers are looking at private exchanges, setting an amount that they're willing as employers to pay toward all benefits, making sure the medical would be affordable with those credits, and letting the employees choose. We've also been really very pleasantly surprised, even with government entity clients where the employees are very used to having a very high level of benefits, especially in the health plan. We've seen employees buy down. And so that's been, I think, very encouraging about the private exchanges. And also we've seen the employees guided through the process with avatars, and that's certainly a feature you want to look to have in your private exchange. Basically an avatar or a decision method. In many cases, it's a person who is asking specific questions of the employees, so they hear a voice, and it's very interactive, and they get to put in information about their situation, and the avatar helps them choose the plan that is the best fit for them. So it's a way for an employer in many respects and in many cases to actually reduce its spend and provide a better benefit match for the employees. And voluntary benefits, the supplements, will be the future as well, and they're commonly offered on that technology platform. As far as the compliance overview, a lot of people are still asking, what is the offer? What is the requirement? The requirement is to offer, if you're subject to the employer mandate, offer minimum essential coverage, at least, to 70% of your full-time employees. This year, 95% will be the compliance threshold starting with the 2016 plan year and later. In order to avoid all penalties, you'd want to also make sure that the coverage is affordable and hits that bronze level. If you have not yet done an analysis of your coverage to make sure that you've satisfied this, it'd be really important to do that. A lot of employers think they're in compliance, and they may or may not be. Who's a full-time employee? It's gauged at the 30 hours or more per week. The IRS interprets this as 130 hours a month, so it's not just the 30 or more hours a week. So keep that in mind. You'll hear references to 130 hours a month. That's how you're going to know whether a person is eligible. when you do the calculation of all hours you've tracked. People who are presumed to be full-time have to be offered coverage within the waiting period or sooner. And then variable hour or seasonal employees, very specific definitions. Not everyone is variable hour and not everyone is seasonal. Certainly you might have someone who you consider a part-time employee, but they may not actually qualify as variable hour. And you may have people who only work for you from time to time, but they may not be seasonal. So very specific and technical definitions. When you look to the law, what are the top compliance concerns? Certainly make sure you know your compliance date. If you're late, don't panic. Panic is never good, but make sure you adopt an approach to complying with the law that is very systematic. A lot of employers have not yet done the analysis, especially in the smaller size groups, analysis of whether they're part of a control group. And that's an IRS standard. Generally, the government looks to whether there's an 80% common ownership, either parent subsidiary or across companies owned by entrepreneurs, 5 or fewer entrepreneurs. There are very complex rules around that. I would strongly suggest you talk with legal counsel. We can provide you with some details around that analysis that can make that conversation much more efficient. As far as a compliant design, you'd want to make sure that you're bringing in all the new plan terms. There's new plan documentation that's required, and making sure that the documentation all matches. That can be very tricky, and making sure you've set affordable premiums. That's probably one of the trickiest aspects of it. It can be done very, very readily and very easily with some very specific employee contribution tools. The compliant administration is a matter of detail. You want to make sure that you've offered coverage to the correct people, that you've got, as I go on to say, proof and documentation. Make sure that you've documented, told the employees if they're variable hour, that you've given them a very specific written designation, not required by the law, but it's a best practice. And how else will they know? Variable hour employee is it's a very mushy definition. It is a matter of whether you as the employer have a reasonable belief that the individual is not going to be a full-time employee. That's variable hour. Seasonal is whether the individual is in a position that is filled at about the same time each year and the position is filled for less than 6 months. In those situations, you want to make sure you've told the employee you are a variable hour employee, if that's the designation. Your job by its very nature means your hours will fluctuate. It may appear to you that from time to time you are a full-time employee, but that is not the case. We will track your hours over a full 12 months, determine if you are eligible by adding all the hours together, dividing by the number of months, 12, which is the most common. If the number is 130 or more, we will offer you coverage for the future. It's never retroactive. And then we go on to address the fact that the individual doesn't have to take coverage and how premiums are handled if the individual's paycheck is insufficient. So a lot of documentation around that, and make sure that you document especially that you've offered the benefits. Ideally, you would get a signed waiver. The Cadillac tax, again, probably the number one concern, and it overlaps both compliance as well as strategic issues. If you're involved with healthcare reform in any way, you've probably got a higher level of involvement than ever if you're in the HR department. It involves and pulls in budgeting, finance, a lot of cost projections, and you want to make sure that while you're taking care of all of these compliance issues that you're on top of other things. For example, the EEOC just came out with some proposed guidance on wellness. It's binding on the EEOC. You want to make sure that you're aware of that and that you're leveraging your wellness program to hold down costs and also possibly simply just to shift costs. So what are the solutions? I would say probably the top 7 things that you would need to do as an employer is the designation of employee status for the variable hour and seasonal people. And at the same time, we recommend buttoning up the full-time employees by telling them their status as well. Making sure you've got a valid plan document for ERISA purposes as well as health reform purposes with all of the related HR materials like the handbooks, the enrollment forms, that everything matches. The third is to have an effective communication campaign with the employees. That definitely needs to be in your 3 to 5 year strategy. Documentation of the offer is number 4. Making sure that you're prepared for investigations and audits. is the 5th item. Number 6 is making sure that as issues evolve and change over time, that you're on top of those issues. And then finally, redesigning your program to avoid the Cadillac tax for as long as possible. And I refer to all of these as really a prevent defense. Very important. Now, we always at this point get a lot of questions and concerns around what is the Cadillac tax exactly. You should certainly by this point be asking for an analysis of your plan's Cadillac tax trigger date if you've not already done that. And of course, the next thing out of our clients' thoughts is, oh my gosh, what do I do about this? And certainly you want to make sure that you've got a strategy around holding down costs and avoiding the penalty as long as you can. And it was supposed to be a penalty on very rich plans, but it really is going to penalize employers for geography. Different areas have different health care costs, and that's really what will be one of the main impacts on the employer. Where is it located? It starts potentially triggered for a plan as early as January 1st of 2018. It doesn't depend on your plan year. It just depends on that calendar year and how much your costs are. The carriers would generally pay the tax, but of course they're going to pass it through to the employer. And an employer with a self-funded plan has the primary responsibility. There's no pass-through to the employees. Based on the way the law is written, we do not think that you can tell the employees, you selected this rich option, so therefore you owe the penalty. 40% is the amount of the tax, and it's based on the amount by which the total annual premiums exceed $2 amounts. So basically it's on a portion of the total annual premium. And when we say total annual premium, we mean the amounts that the employees and the employer pay together. Whatever the insurance carrier, for example, charges for the fully insured plan. Another way to think about it would be your COBRA rate minus the 2% administrative fee. And so if your premium is higher for single coverage, I've got an example on the slide. I'm not going to read through it, but you can see how that works. And you're going to impose it. It would be imposed and paid based on the number of individuals electing single coverage and on the number of individuals electing family coverage if you exceed the dollar thresholds for both. It applies to each option that you have. It's barely indexed. It is indexed in such a way that every employer will eventually hit that because medical trend is much higher than the indexing that applies to this. You're going to look at the lowest, not the lowest cost option, but exactly what individuals have elected. And we believe that it's going to be calculated on an employee-by-employee basis depending on what they've elected, because it's not just your core medical plan that's going to be tied into this. All of the account-based plans, HSAs, HRAs, FSAs, those count. The only thing that's not subject to it would be the post-tax employee contributions to an HSA. We don't see this going away. It's popular that it comes up as a repeal topic. You know, should it be taken away? Should it be repealed? Unfortunately, the federal government has spent most of the money that the Cadillac tax represents. It's designed, this tax is designed to pay for 25% of the federal government's cost of health reform, all the subsidies, everything that's been spent already. So certainly they'll replace it with something else if it goes away. Now let's look at some of the top administrative concerns. IRS reporting should be your #1 administrative priority, making sure that you have a system that is going to be gathering information about your employees so that you know who's full-time and who needs to have a report done, and making sure that you have a system in place. I say this only half-jokingly. If you're subject to the reporting requirement and you attempt to complete the reporting manually, whoever is assigned that project is probably going to quit in the first quarter of next year. It's an overwhelming process for many people because it's on an individual-by-individual basis, and the very specific codes that go into the boxes that on the IRS form are specific to that individual and will vary depending on things like start date. So only the very smallest employers, over 50 full-time employees, so let's say someone with 52 full-time employees, only those very, very small employers might even be the only ones who would want to risk completing the forms manually. And again, even in that situation, whoever is assigned that project is going to be extremely unhappy and want to quit. And there's also exposure. If the forms are not accurate, you're going to need to correct them. Technology is going to be your friend on this. Making sure that the employees are told of their status, as I was describing before, making sure that they know where they fit so that they understand their eligibility. A big part of that is so that they do not complain to the federal agencies or bring lawsuits asserting they should have been offered benefits. Make sure they know where they fit, what the rules will be for their eligibility if they should ever become eligible, if they're variable hour or seasonal. Make sure people understand what the program is. Plan materials need to match what your program is offering. Making sure that you've trained people in the HR and Ben Admin office, especially around the new technology, and also making sure that managers know what they can and cannot do. And we've heard some pretty serious situations where managers have been, for example, pulling people off the floor if they start to exceed 30 hours in a week if they're variable hour. And that's not technically required. It may be a great way to try to manage people to below 30 hours in general, but it is not required, and you don't want the tail wagging the dog. You don't want a production line to shut down because someone's been pulled off the line. And just make sure you're ready for those audits. Again, stressing the prevent defense. So let's dig in a little deeper on the technology. Really one of the main things that you need to do is make sure you've vetted the technology. Make sure it does what you need it to do. Make sure it will work with your payroll system. Make sure it's got everything it needs to interface with the IRS and to complete the forms that you need completed accurately and in a timely manner. The timely manner, the deadline, is the #1 issue this first year. The first year you have to hit the deadline. We have a whole team assigned to this, and you do need a number of people to vet these programs. It's really too much of a job for a single person. Very detailed information needs to go into that analysis. You want to make sure that you've got detail and really a great deal of evaluation around hours tracking. Is the hours tracking done on every hour that needs to be tracked? How is it calculated? Are there very specific issues for your type of business? For example, do you have, are you in agriculture and do you have seasonal employees? Are you in a healthcare system? Do you have per diem employees that have traditionally been treated a different way? Dealing with all of that is going to be very important, even down to the technology level. You want to make sure that checklists were built into that, and you also want to make sure that the system has been programmed in such a way that as the law changes, or if they've made mistakes, that they can simply pull out one piece and recode, that it's almost been programmed as a story, as various segments or stories within the larger program. And you're going to want more comprehensive tools. And I promised a wish list of things, flags for various things like pay changes, leaves of absence, people changing from part-time to full-time, people changing from full-time down to part-time. There are very specific things that need to happen if somebody is full-time like me and then goes to a part-time position. You'd want automatic calculations for affordability and recalculations if someone's rate of pay changes. If they go from 20 hours or $20 an hour to $15 an hour, you want to make sure the coverage is still affordable. You'd want a full admin system really for the entire employee life cycle, from date of hire all the way through to termination of employment and COBRA administration. You want to make sure that as much work as possible is taken off of your desk, and also the more automation there is in the system, the less risk there is to you as an employer. Making sure you've got that Cadillac tax trigger built into that, and the expected date. If you're self-funded, I would suggest looking at this much more frequently. Allocation of the community rating premium for smaller employers. We've got that modified community rating coming for this next year, and it's very tricky. Automation of wellness differentials, and you'd want that built into the system so that you're not having a lot of information put in manually on that. It really supports the privacy that the EEOC wants to see. So let's move into hours tracking and reporting and just some action items around that. Certainly the vendors are going to need to be involved with that. A lot of employers that have done nothing, again, if you're in that boat, if you've just not really come into compliance yet and you haven't begun tracking hours, If you're late, it may not be too late. I cannot, and at this point, no one can guarantee that you're not going to get hit with penalties, especially if you should have already complied for part of 2015. But it is possible to take the information that you have and to transition into compliance with payroll, hours information, and certainly coming into that would be very important. Vetting the processes and making sure that it's got everything you need, all the way from the bare basics, which I call the table stakes, to the user interface. Make sure it's something that is user-friendly. Make sure that they provide a sufficient amount of training. Make sure that you've got a vendor, especially if you're going to be submitting electronically. If you're over 250 forms needing to be completed, you're going to need to file those forms electronically. And the interface is called XML, Extensible Markup Language, and it's very important for the interface between your vendor and the IRS. Looking at the acceptance of liability, will your vendor accept liability? Most of the vendors do not. I think it's going to become an industry standard at some point, and it's certainly something that we look for in a contract. With the penalties having just been increased on the reporting, now it's $250 per form, and that's separate for a failure to hit the deadline or a failure for the form to be accurate. Again, the first year accuracy does not apply, but very significant penalties, and they max out. Both penalties separately would max out at $3 million, so it would be a total of $6 million exposure. Very expensive, and of course, you know, higher for larger companies, but very expensive. The way a system is programmed may affect some decisions you've made or would like to make on compliance, so you want to make sure, again, that it's nimble. And if you're in a certain type of industry, for example, education, there are different rules that apply, different hours tracking rules, hours crediting rules. If you're involved with a staffing firm or a union, there's additional things you need to look at. So make sure that the system works for you. Let's move for a moment to the government exchanges and what the impacts are on employers. When we look at the impacts of the exchanges, this first year, certainly we've got the compliance threshold at 70%. Subsidies will trigger penalties. What we imagine is that your obligation as the employer is going to be to defend yourself. And you're going to need to say, okay, this employee may have gotten a subsidy, but we're within our 70% compliance threshold. Or in future years, you'll have to defend at the 95%. And there are other ways you can defend yourself as well. The penalties to an employer are prorated based on the number of months, and they are limited by your tax ID number. It's a pretty good thing to have multiple tax ID numbers within an organization. That $2,000 sledgehammer penalty is limited by tax ID number. So what do we look for in the future? Fewer exchanges. Some states are dropping and expected to drop. Larger companies that are multi-state may actually prefer if we had a single state exchange or a federal exchange and it operated in every state. But for now, that's not the case. A lot of state regulators have been asserting that employers were out of compliance. State regulators really do not have jurisdiction in that regard. All of the enforcement is going to be done by the IRS. We have seen the state regulators now backing off of sending employers notices saying that they're out of compliance, which is a good thing. Those letters have been very misleading and quite inaccurate, so we're glad that they have pulled back from that. We talked a little bit about, do we expect things to change? What are the expectations for future change in Washington? Let's look at that. Again, I prefaced all of this by saying I commonly give bad news. Better to know, better to have good planning. I believe we don't expect any changes by Congress. You know, certainly in advance of the next election, the Democrats would like to say, well, we've addressed health care reform. We were able to get that through. I supported it. Republicans will be saying, well, we don't like health care reform. We want it changed. They like that as an election issue. If you've ever heard Dallas Salisbury, who used to be the director of the Employee Benefit Research Institute, he would always say that Congress really does not want to take on and actually pass additional legislation at a time like this right before an election. A lot of things would be desired, maybe changing the application of the law to larger employers only, to people working 40 hours instead of 30, Cadillac tax being eliminated, changes to small group rules. We just don't see anything like that happening. The President has already indicated he would veto many of these changes, and there would not be a two-thirds majority in the House and a separate two-thirds majority in the Senate to override a veto. And quite frankly, a lot of the senators say what many believe to be true, and that is we've needed health care reform for some time, and there is a sense, even though people are not, the politicians are not very assertive about saying this, but there's a great sentiment in Washington that they want to see how the law plays out. We may see some things up for negotiation. If so, there would need to be compromises. We may see some health care reform changes, very limited changes coming through with other issues like immigration reform. One of the things that we've heard that Congress may want to fix in advance of the election is the family glitch. Only individual employee coverage needs to be affordable. That's the family glitch. A lot of people had expected that family coverage would be set at affordability as well. That's something that Congress might take on. But again, it would require a compromise and not be good for employers. So again, be careful what we wish for. More change at this point in time is probably not a good thing, because anything that they make easier for employers, there's going to be something on the other side of that makes it more difficult. So we'll be looking for changes more likely after the next election. We'll certainly continue to see lawsuits. There are lawsuits around funding, and they will take time. It's going to make require a lot of time to make its way through all of the federal courts. And the IRS is really more concerned at this point in time about funding. And while that works its way through the courts, the IRS has certainly shifted individuals to looking for more revenue. There have been a large number of IRS agents assigned to the audit approach, to the audit group that will be specifically trying to get revenue based on employers that have not complied with healthcare reform. They view the employer mandate as play or pay, and they certainly are expecting employers to pay. The Cadillac tax, again, we don't see a lot of changes to that, and certainly if they did change that, or if they change any other aspect of the law, may affect federal revenue, and we would expect to see a different tax pop up so that the law remains balanced. Long-term impacts, we don't see a huge increase in the election rate for employees that have not previously elected benefits. We generally see around 9 to 13% election rate. That may increase a little bit. It did increase somewhat. Even the exchange election rate increased somewhat after April of 2015, when people realized that they were going to be hit with an individual penalty if they did not have group insurance. But even across the country in the exchanges, the figures I've seen have only reflected about 1.9 million people electing coverage after they realized they would owe a penalty. So not a huge shift. We may see more elections in 2016 when there's more individual mandate enforcement starting around May. We may see that increase more significantly in 2017 as the penalty has gone up and as people are more educated about it. Most people still, though, lower paid individuals, look at the amount of the penalty and they look at the amount that they have to pay for premiums. Even someone who's never been offered insurance before, people are maybe unsophisticated, but they are smart, and they will look at that. So a lot of people in that lower income range decide to simply pay the penalty instead, the individual penalty. So will the insurance exchanges have a long-term impact on employer plans? Probably not. Probably not. The employer penalty will, but not that. Let's move into a little bit more about the prevent defense, because I do want to focus on what do you need to do, what can you do. And I've mentioned best practices several times. These are just 5 examples. You really need a systematic approach where all the materials you have and all of the processes that you adopt are designed to interact, and they're customized for your program. You'd want to make sure you've told the employees what their status is. You want to make sure you've got a 3 to 5 year strategic plan, a written plan. It's not etched in stone. Leave some flexibility, but make sure you have that. Make sure all of the materials correspond. in your formal plan documents, as well as the employee-facing communication materials, and make sure they're rolled out through that 3 to 5 year strategic plan. Make sure your HR practices, for example, how a job is advertised, your job descriptions, that they match how you're treating individuals in those positions. Make sure that managers know what they can do and they know what they cannot do. We have had situations I mentioned earlier about people being pulled off the line. I've also encountered recently situations where managers terminated people once they reached 1,500 hours. Approaching that magic 1,560 hours number, that is illegal. It's impermissible to terminate an employee who looks like they're going to be earning benefits for the next year. That's not allowed. Make sure that the managers understand that. Prepare for what ifs. There are things that we can anticipate and things that we cannot. Prepare and leave yourself some room for flexibility. Certainly if you find out that you're out of compliance with respect to an individual, you've got to make sure before you promise them coverage mid-year that the carrier will allow that. So make sure that after you identify a problem that you can actually solve it before you attempt to. Manage the employee communications. That cannot be stressed enough. We offer benefits for employee attraction and retention, and we want to make sure that that is taken care of. Action plans, make sure you're prepared for investigations, lawsuits, complaints, and make sure that technology is your friend. Make sure that that's part of your defense. And make sure you're not doing things you're not supposed to do. Individual policies, you're not allowed to pay for those or to reimburse those. Regardless of your size, this applies to all employers. You are not allowed to do that. You can offer a defined contribution, for example, with group policies, but you cannot do that for individual policies. We find a lot of these during conversations with finance, one-off agreements with individuals. I've already talked about termination of employment and not to do that for people becoming eligible. There are some payroll tax avoidance scams, and if something seems too good to be true and you're reducing your payroll tax, make sure you do not do that. A lot of those programs keep referencing it's a 105 plan, or we're leveraging 125 and running the money through the cafeteria plan twice, all illegal. And then if you do work with a vendor that seems to be pretty close to the line, make sure that they're in compliance, that they're not doing something that's illegal. A lot of employers are having Medicaid enrollers come onto the work site to help employees enroll in Medicaid. It's not illegal, but it's tricky. Similarly, we have worked with some vendors that are looking to see whether employers qualify for tax credits. That's allowed, but you want to approach that in such a way that you're not potentially discriminating against certain employees. Always engage your legal counsel on employment-related issues. And you want to make sure when you're putting your program in place and changing from year to year that you always review the agreements and that you make sure you've got a relationship with a partner. For example, your stop-loss vendor, if you're self-funded, that all these agreements listed, that you're going through them, and that you've got the protections that you need. And especially if you do go self-funded, things like your HIPAA agreements with your business associates are bulletproof. And making sure that your vendors can actually do what you need to have happen. We do anticipate things like changes to the Box 12 of the W-2, and certainly changes with the Cadillac tax. And you want to leverage and make sure that you're getting the most out of every vendor. Sometimes it's great just to revisit those to see if you maybe are paying for something that you've not been using. Another thing we strongly suggest is creating a fiduciary file, making sure that you've got all the documentation that would be appropriate if there should be an audit. Shoot the gaps, upgrade what you have, and update it as needed. And I would suggest and it's easy to envision this as a paper file, but you can also do it electronically on your server and have all the documents that the agencies would look for. And we've got a model fiduciary file for that. Know your playbook. Follow your strategic plan. Change it if you need to. If you're in HR, make sure that you're in front of finance. Make sure that you're working with managers. Make sure you're working with the CEO so he understands your obligations, and make sure that you've got buy-in across the company for what you need to do, and make sure those managers know what's going to happen, what the changes are, and pushing for things that need to happen. A lot more implementation is happening. And then one caution, guard your playbook, guard your 3 to 5 year strategic plan, because it may change and it may scare the employees, especially some of the dialogue around the Cadillac tax. So let's talk about some of the strategic compliance tools that you should be using. You should have some sort of health reform workbook, so you're determining your size. We have one of these, and our clients find it very helpful. They're able to determine when they need to comply. They're able to determine and document in case the IRS ever says, prove to us that you get to comply on your plan year instead of 1/1. We have a reporting toolkit, vetting of the vendors. I spent quite a bit of time on that already. The designation forms, telling the employees what classification they're in. Templates for coordinating and revising handbooks, making sure that everything fits together. Making sure you know your Cadillac tax trigger date and what you're going to do about it. The fiduciary file that I just mentioned, and a complete compliance review. I'm involved with many of those, and we find problems. It's best to fix them first. Now let's talk about industry consolidation and the impact on you as an employer. Who's consolidating? Well, just about everyone. All the insurance carriers, you can see that in the media. It does reduce choice, which increases costs. Hospitals and health systems continue to consolidate. Advisors, consultants, brokers continue to consolidate. People need a much higher level of expertise. And our people always say, well, I wonder if our competitor has a Sibyl or a Michael or a Jack or Francis or Dennis. You know, you need to have an attorney that can get their arms around this and give good advice. So advisors are consolidating. Your broker that you use today may end up being part of another larger organization, and it should be a win for you. Make sure that you're following all of these types of consolidations of vendors. We're going to see physician practices further consolidate, some with the health systems. Provider networks are shrinking, and we're going more toward limited networks. And the impacts, again, often costs do increase. There's not as much choice, not as much competition. Would antitrust law prevent this? We don't see the federal government engaging in blocking these mergers and consolidations at this time. Looking to the future, more consolidation and a higher emphasis on consulting firms. Certainly a consulting approach is what you're going to need. The traditional approach of making sure that you get the best rate, that's not going to be the main issue you're concerned about. It'll be one factor, but it's not just getting a bid that is the lowest cost bid. You want to make sure that you've got all the services you need, whether it's from a carrier and the support you need from them or from your broker, from your consultant. You want to make sure you've got it all. With less competition, look for more cost, and we will see more direct contracting. So what are employer health plans going to look like in 2020 and beyond? Your benefit package is probably going to be moving more toward managed care. You're probably going to be at least looking for self-funding. And again, if you do go self-funded, make sure you understand that if your liability increases because your claims are high, you could get hit with the Cadillac tax because of that. Always a risk conversation. Make sure you're on top of the discrimination rules. Make sure you understand how the law will play out in terms of total compensation. The law may mean that you need to address employee compensation in a much different way. People may expect and get a higher total salary. Employee retention, probably the #1 trend in employee retention is offering benefits to the employees that are supplemental. And the #2 trend is that increased compensation that I just mentioned. Account-based benefits are probably going to be the ones that are terminated first in the face of the Cadillac tax. When you do takeaways like that, whether you're taking away those account-based plans or bringing down the value of your core medical to avoid the Cadillac tax, you're looking at offering and needing to offer supplements. And there will be a tipping point at some point where core medical is not going to be necessarily an offering by employers, and that's going to make those supplemental coverages even more important. And they've evolved so much more quickly in the voluntary benefits area, and because of that, they're attracting consumers who never really would have thought about getting a voluntary package in the past. Case in point, I bought an accident policy for the first time. It really can help make up for cost shifting and higher out-of-pockets. And that really concludes the formal comments. I just want to really conclude my formal comments by saying, if you're not yet ready, push to get ready. And if you're in compliance, make sure you stay that way. Make sure you take care of any of the issues I've mentioned today. Put in any of the systems or tools that I've mentioned that you don't currently have, and that you stay on top of all of the issues. And I believe we have some time now for questions.
Thank you so much, Sibyl. I was scrolling through the questions to get myself organized. The first question that's come up, and it's a good one, an employer asks, if we've done nothing, what should we do? Is there, like to send the penalty fee somewhere, or is it too late to come into compliance?
It's not too late. I always say it's never too late. You may face some constraints, and quite honestly, you may face some penalties. At this point in time, if you were supposed to come into compliance for 2015, we do have access to markets and can put a program in place fairly quickly. Certainly you'd want to get it in as soon as possible, because any month that you should have been offering benefits that you're not offering benefits will represent an exposure. The penalties are prorated. What we also like to do is come up with a discussion for you, which will show you what we expect the penalties to be, and we would recommend reserving. And what we essentially do is go through and really apply all of the defenses that would result in reduced penalties, and then we document everything, make sure the program is in compliance going forward, and making sure that you've offered benefits to everyone who would be eligible, looking at the hours for the variable hour people and the seasonal people, and making sure somewhat after the fact that you're able to come into compliance. Again, we can't promise retroactive compliance, but certainly bringing you in and making sure that we're taking care of everything going forward is crucial.
Thank you, Sibyl. Another question asked by one of our participants. Do you recommend an orientation period for employers who experience high turnover in short periods of time?
Oh, that's a great question. The waiting period regulations reference an orientation period. However, if you are subject to the employer mandate, generally if you have more than 50 employees, we don't recommend putting in an orientation period for this purpose. In 2016, you'll be subject to the employer mandate if you have more than 50 employees. Right now it's over 100. If you put an orientation period in, the problem with that is that you may owe penalties under the employer mandate rules. The IRS does not do a good job of making sure that their different provisions match. And so you could be in compliance with the waiting period rule by putting in an orientation period, but out of compliance with the employer mandate rule and face the employer mandate penalty. And the orientation period, it's only 1 month, so it doesn't buy you very much time, and it's supposed to be a bona fide orientation period, meaning that they want to see some sort of an onboarding process, and they'll also want to see that some sort of an evaluation is done of whether that particular employee would be continued. And a lot of our clients, quite frankly, don't want to put it in, not just because it's only 1 month, but because they don't want the federal government getting into their business and looking at how orientation periods might have applied to particular individuals. So I do not recommend it if you're subject to the employer mandate. If you're below 50 employees, you're complying with, or you're offering a policy voluntarily to your employees, you could put in an orientation period, but it really doesn't get you very much, and there's administration around it.
Thanks, Sibyl. Another question we have, a good one. We have contractors who are enrolled in benefits. Is this going to be a compliance issue when filing this year, and they are not employees and not on our payroll? I know that other people on our faculty have said, that's subject to opinion, but I wanted to kind of get your thoughts.
Well, it's not gonna necessarily reflect a violation. You've just been more generous than the law allows. by having the contractors eligible. Quite frankly, we often see the opposite. We have employers who have people who they think are independent contractors, but they're actually employees. I would do an examination and just see, sort of an evaluation. Are these people independent contractors or are they employees? And you could use the IRS form SS8 as sort of a worksheet for that. Do not file it with the IRS, because if you've got a problem, you'd basically be admitting that you've got someone misclassified. So I'd look first at the classification issue. If you cover someone under your plan and they're independent contractors, if you're fully insured, make sure the carrier is aware that you've got non-employees covered. The IRS will receive reports from the carriers about the actual coverage for those individuals, and if they truly are independent contractors, you're not required to report them yourself as an employee on the form 1095C. Now that's if you're fully insured. If you're self-funded and you're covering independent contractors, you're going to need to report on the coverage those individuals actually elect, and I think in that situation you're going to be confusing the IRS. So if you're self-funded, you might consider not doing that any longer. You're also making them look like employees if you're offering them benefits, and so, you're really taking on an additional risk, and probably you're going to make them look like employees and maybe raise misclassification issues regardless of your funding type. I don't recommend it.
Thanks so much, Sibyl. Great answer. Another question we have, I know for the Cadillac tax that contributions to HSAs, FSAs, and HRAs go towards the tax amount, but do you see a bigger play with GAP plans since they are exempt?
Well, yes, I do. Any sort of a GAP program that is an exempt supplement, you'd have to make sure it qualifies as what's called an accepted benefit under healthcare reform. But if you've got a program that's not subject to healthcare reform, I see a much bigger play for those programs. Again, make sure they're designed actually to be exempt from reform.
Also, another Cadillac tax question. Is the employer contribution to an HRA or HSA added to the total health insurance premium to determine the tax?
Oh, yes. The employer contribution to an HRA, an FSA, or an HSA would count, as well as any employee money for the HSA and FSA. So it would be the employer contribution as well as the employee contribution. We do see employers looking to cap the amounts that they will contribute and also the amounts that employees can contribute. And certainly, rather than pay a Cadillac tax on those accounts, employers will eventually terminate those programs.
Right. We have a few more minutes and a lot more questions. I'm going to do my best to get to the ones that are kind of, I'm just reading through to summarize. So here's one more. Can you expand on how best to handle employment status change from full-time to variable, part-time, less than 30 hours expected, or real options in compliance with the law?
Oh, okay, great. So this is a great question. So an employee like me who's full-time transitions to part-time status. There's a little-known provision in the final regulations from February of 2014 which describes what needs to happen. Generally, the employer, you would need to put that former full-time employee into a monthly tracking system, even if you use a 12-month measurement period for all your other part-time and variable and seasonal employees. For that former full-time person, you can use it, a monthly tracking period. You would have to determine whether that person actually is working part-time. And so let me use myself as an example. If I move from full-time status to part-time status, my employer would have to track my hours for the next 3 months. So if I go into that status now, they would have to look at my hours in September. Am I full-time in September, yes or no? 130 hours, yes or no? In October, yes or no? In November, yes or no? So in the next 3 months, consecutive 3 months, am I actually working part-time hours? And when I do work part-time hours, at that point in time, I can be removed from the plan the first day of the 4th month after those 3 consecutive months of part-time status. So it allows for transition periods. People look at the rule and they say, oh my gosh, this is so tedious and I'm going to have to track this person's hours. The IRS views it as a rule that's favorable to the employers. It allows the employer to actually get that individual off of the plan earlier than they might otherwise, and it also means that the employer does not necessarily need those hours, actual hours worked for that full-time employee while they're working full-time. It does delay the COBRA event until the individual is actually removed from the plan.
Excellent. Thank you so much. We have time for one more. I know it's 2:01. I want to honor the time that folks have given us, but this is a really good question. I'm hoping you can answer it. So we are a medical practice where physicians are owners and pay full cost of their medical insurance. Should they be reported on the same employees, as employees, and should they be reported the same as employees, and if so, what about the fact that they pay 100% since they are owners and not employees?
For this situation, I would suggest that as owner/employees, they be reported. Right. That way the IRS will have information about the fact that they were offered benefits. Even if they pay 100% themselves, there's not going to be an issue of affordability because their income level will be so high. That way there would be complete reporting. There may be some exceptions that could be taken advantage of, but that's generally what is recommended for owner employees. They're going to end up showing up as having been offered coverage, and that will help to correspond to either the report that the carrier will be providing about the coverage or the report that the employer would produce if the plan is self-funded. And it also helps to insulate those physician owners from additional individual penalties.
Excellent. Well, this does conclude our webcast. Sybil, thank you so much. For those of you on the call that would love to meet Sybil, she'll be speaking at our annual event. It is next month, September 27 through 30 in Orlando, Florida. For those questions that didn't get answered yet, we will go ahead and send those over to Sybil so that she can address them. If you're interested in attending the conference and meeting Sybil and others just like her and meeting Hub and kind of understanding how they could help you as an employer with your plan, you would be able to do that at our conference, or they'll be reaching out to you as well to see how they can help. We know that this is a major point of pain for many employers, and we thank you guys so much for joining us, and we hope that we've been able to bring some clarity. We thank Sybil so much and Hub for bringing this excellent information forth, and for those of you that have questions, of course, we'll again get those answers as best we can. And Sybil, thank you for joining us and for this great insight.
You're very welcome, Jenny, and I look forward to seeing you at the conference next month.
We look forward to seeing you as well and hearing from you. And again, we'll be getting these questions over to you, Sybil, and certainly some follow-up out to the folks that are on the line. We'll present these slides along with the replay as soon as we can get it edited and out to everyone. So thanks. Hope to see everyone next month in Orlando, Florida. If you have questions, you can certainly call me. 561-790-1176 is my number. And again, it's Jenny. Thanks so much, guys. Talk to you soon.